Mr. Surless.
Good morning, Your Honors. May it please the Court, my name is Andrew Crouch, and I represent the defendant, Thomas Knowles, in his appeal from the Malden District Court. This case stems from an encounter that an officer, Officer Mann, of the Malden Police Department had with Mr. Knowles based upon a dispatch report from an anonymous individual claiming that there was a person at a Ferry Street in Malden swinging a bat. That is the full extent of the conversation that the anonymous source had with the dispatcher, which was relayed to Officer Mann. Now, when Officer Mann arrives at the scene in that case, he doesn't see anybody at the exact location mentioned. But when he does, drive around the block a little bit, turns and looks around the block, he sees an individual matching the description, wearing a white shirt and blue jeans, who has the bat. So,
and this, I take it, is literally seconds after the call has come in?
That is exactly how Officer Mann testifies.
What time of the day was this?
This is about 6:40 p.m.
In September?
Yeah, in September.
It was
Still light out.
Still light out, yes. And Officer Mann doesn't testify that he has any problem from at least 50 feet, identifying this individual. But it is also important to note that there is nobody else.
And the call that came in, was he swinging the bat?
Swinging a bat is, I think, is Officer Mann's exact words.
This is a busy street, is it, or?
Actually, that is what the motion judge found, but there was no evidence on the record to support that whatsoever. And the appeals court also
corrected that, correct?
Yes, and the appeals court indeed corrected that. Said that actually Officer Mann testified that there was nobody around with the exception of this one individual. And so when Officer Mann sees the individual, he drives down the street, and as he's at that point, the individual has his back towards him. And he's leaning into the trunk. He actually has a baseball bat in his hand. And as Officer Mann pulls up, he pulls his car diagonally across the street behind the individual. The individual puts his bat down behind him, leans it up against a post or a telephone pole behind him, and then continues to lean into his trunk. Officer Mann steps out of the vehicle. The individual then sees him. The individual reaches into his pocket and throws some unknown object into his open trunk. And those are the facts as they are important to this particular case. Now, what happens from there forward is obviously what we're here to discuss today. In the decision itself, the motion judge made several crucial errors that I talk about relating to underlying factual conclusions that relate to his decision to deny the motion to suppress. The appeals court in its decision largely agrees with the defendant and corrects a lot of those errors, and actually largely agrees with the defendant in all of his arguments up until the point of where the actual decision was made. The decision the appeals court made was actually not based upon any issues that were presented at the motion hearing or at the appeals court hearing, or briefed whatsoever. It was on the community caretaker function and the emergency exception to the warrant requirement. Those are the two bases that the court found as alternative reasons to uphold the motion judge's decision to deny the request to suppress the evidence.
You're talking about the appeals court. Did the appeals court actually say there was reasonable suspicion? Because they say, nevertheless, even if there weren't reasonable suspicion, the caretaking function comes in. In the preceding paragraph, at least as I recall it, they never specifically go so far as to say that there was reasonable suspicion.
In the way that I read the decision is actually, they may have not been explicit about it, but they certainly said that he was not engaged in criminal activity. And so I think that would go in part and parcel, obviously, with the reasonable suspicion standard. And the motion judge himself found that mere swinging of a baseball bat was not an indication of any illegal behavior. I think the appeals court and the hearing judge both found it to be maybe unusual behavior, but certainly not anything that stemmed to the point of being actual reasonable suspicion.
So when did the seizure take place?
The defendant would, and the defendant argued this before the appeals court, that the seizure would take place when Officer Mann, in a show of authority, pulls his car diagonally across the street.
But did he block him off? He didn't see that.
He said he pulls it he did not see it. That is
the
correct.
defendant was not aware of that.
Correct. So I would say the seizure occurs when the individual turns around and sees Officer Mann in that show of authority. To the extent that the court would not necessarily agree with that, the case law is developed in a way that it sort of seems like both sides have to be blocked, or at least the access route has to be blocked. Then we would say that it certainly happens at the time when Officer Mann makes his statements to the individual.
And what precisely are the commands that the officer gives?
The officer specifically tells the individual that officer says he ordered the defendant to stop where he was and to stop at this time and then to just come towards me and to keep his hands out of his pockets and start walking towards me. So at that point, the individual turns around, marked police cruiser is parked diagonally across the street. The officer is ordering him to stop where he is, to come towards him. And one of the things that's important here is that the individual complies immediately. He immediately starts walking towards him, and then within seconds, Officer Mann testifies, 3 other units respond to the scene. So at that point, I think it is clear with Officer, and this is what the appeals court finds as well, that this is the point at which he is seized when the officer, at least at the point when the officer issues his orders.
And your argument is at that point there's no reasonable suspicion, so it's an illegal seizure.
Correct.
So what does that got to do with the trunk? The trunk's open, right?
The trunk is open, but he seizes him at that point, and the officer is not in a position at that point to take any sort of a plain view search of the trunk. At that point, he freezes the scene, and I think the case law has developed to suggest that the officer at that point needs to have, to continue that plain view situation, needs to be lawfully in the position that he's at. And at that point, he has seized the entire scene. He's stopped Mr. Knowles. Mr. Knowles is now walking away from the trunk. I think the problem is at that point, if he is indeed seized, he is frozen. He's essentially frozen the situation.
Well, let's say the scenario was like this. You've got this, say it's an illegal seizure. Stop, come here. And another officer who arrives just walks around the car, looks in the car, and on the seat sees a big bag of drugs. Are you saying that search, so to speak, would be the result of an illegal seizure? Isn't that a plain view search? The officer could have been there in any event?
I would say that at that point, I think it does. I don't know that the case law has quite developed to that point yet, but I would think that indeed that is also the product of a seizure, because Mr. Knowles, or the suspect in this case, not free to leave the scene. He's not free to, we can't obviously speculate as to whether or not he might have, just gone into his car and driven off at that point, negating the opportunity to have the plain view. But the scene is frozen at that point due to the seizure.
Why wasn't that reasonable? I mean, the police officer heard a report that somebody was walking down the street swinging a bat. It may not be criminal, may be perfectly legitimate, but it might be a problem. So he's going down there just to inquire, just to see what's going on, and lo and behold, there's somebody meeting the description, at least by clothing, and there's a baseball bat. It's propped up against a telephone pole. The police officer, isn't it reasonable for the police officers to at least make inquiry, and in order to do that, to freeze the scene, to say, get away from the baseball. He doesn't say get away from the baseball bat. He says, come towards me, after he had seen the man throw something into the trunk. Isn't that reasonable, just to freeze the scene temporarily?
I think that the first point that we need to get to is there is no allegation that he's actually walking down the street. It's just that he's swinging a baseball bat. And so then when Officer Mann comes, he's not in the process of making an inquiry. What he does is he pulls the car diagonally across the street, then immediately gets out and makes his orders. So he's actually seizing the scene. I think that there needs to be, obviously at the time of that point, reasonable suspicion of criminal activity, that he's either engaging in, has engaged in, or is in the process of engaging in some sort of criminal act. I don't think that there is a reasonable argument to be made that that can be drawn from the record.
But this guy could be a nut. He doesn't have to be a criminal. He could be somebody who's furiously insane walking down the street swinging a baseball bat, and the police officer has some obligation just to check it out, doesn't he?
He can certainly make inquiry, but he can make inquiry short of seizure. It's the point where actually...
How does he do that? You mean if he had seen the man walking down the street with the bat, couldn't he say to him, put the bat down and come over here, I want to talk to you?
When he says put the bat down, I would argue that that is a point of seizure.
Is that unreasonable?
I think at that point it's still seizure.
It's seizure. Is it an unreasonable seizure?
I think it is an unreasonable seizure because he needs reasonable suspicion of criminal activity. I think it needs the second part of that standard.
Why not a reasonable suspicion of dangerous activity? Why isn't that enough?
Because I think this is sort of what we look at when we start looking at the community caretaker issues. And at this point, I think one of the big distinctions that needs to be made in the community caretaker cases is those cases typically, in almost every case, don't involve seizure.
But they usually involve, at least the reported cases involve, going to the aid of somebody in distress.
Correct.
But police officers are always going they're responding to calls about a gas main break, about it doesn't necessarily have to be illegal activity, and it doesn't necessarily have to be somebody disabled. It could be just a potentially dangerous scene. And is that all the police officer was doing in this case? Responding to, he just wanted to check it out to see if it was a dangerous
I would suggest
scene.
no, and I would suggest that one of the things we can also look at is that 3 other marked cruisers show up at the same scene. They're not all
He's seized.
Yes, I mean, I'm saying that, no, but in terms of, when we talk about community caretaker, the Katie versus Dombrowski case makes very clear that it needs, that the community caretaker function and that limited function needs to be totally divorced from criminal investigation or the acquisition of evidence. Here, we have 4 marked police cruisers converging on one scene. That is entirely consistent with investigation of criminal activity, not just mere inquiry as to what's going on. It's not as if the officer just pulled his cruiser, right up next to the car and said, hey, what's going on in this situation?
But talk about the police officer who actually told him to stop. He doesn't know whether this is a crime. He doesn't know whether this person is mentally ill walking down the street.
He has absolutely no evidence whatsoever to suggest any of that.
And is there any reason to believe that his command to get away from the baseball bat in the back of the car, he didn't say get away from the back of the baseball bat, but the bat was already down, come over here, he just wanted to talk to him. Was that unreasonable?
I still keep, and this is a point I keep coming back to, I think that it needs to be viewed within the respect of whether or not it's criminal activity. If it's not criminal activity, then yes, it does by definition become unreasonable. There are certain very...
If it were a community caretaking function, if it were just hazardous, a hazardous situation, why would it be unreasonable for the police officer to tell him to stop?
That would move into the emergency stage at that point, and that takes it out of the
why, so
question.
why wasn't that what we have?
Because when you just look at, I think, from an objective view of the facts of the case, I don't think that there is a legitimate question that there is any sort of emergency situation. What we look at here, and the appeals court decision doesn't really seem to suggest that there is an emergency situation. When we look at the emergency cases, we talk about things like what you're talking about. Bridges are washed out, water mains are broken, things of that sort. What here, the officer, when he comes up to the scene, what he sees is just an individual leaning into his trunk. There's nobody else around.
Well, didn't he actually see him lean the baseball bat up against the pole?
He did. He sees him lean it behind him, and he's fiddling in his trunk at that point.
So he had received a report that a man was seen swinging a bat. He sees someone lean a baseball bat up against the pole. Is it unreasonable to think that this person, this is the person who was swinging the bat, and maybe he's off his meds? Or?
I think that the first part, it is not unreasonable. The second part, it is. I think it is not unreasonable to think, since it is within seconds, it's not within 20 minutes or half an hour, that he does respond in seconds, that it is reasonable to find that that person's swinging a bat. This story, obviously, the situation completely changes if, it is indeed a busy street, as the motion judge errantly found, or if indeed there was an allegation that he was swinging it at somebody. If he's just swinging the bat, I don't think that leads us to any sort of conclusion that there is any sort of mental instability without more. In this case, the officer doesn't testify that he has any familiarity with the individual in terms of providing any basis for that. What we see is activity that's consistent entirely with innocent behavior.
I take it the officer is not justifying his seizure of Mr. Knowles by saying that he was exercising his caretaking functions and was concerned about the man.
Correct.
Have a
what we see in those cases, and pretty much all of the community caretaker function cases almost follow the exact same pattern, which is almost always involving a car and people in cars either on the pulled to the sides of the road with hazard lights on, who are sleeping in the car, who seem to be passed out or in some sort of medical stress.
But it doesn't have to involve a car.
No, I suppose it wouldn't, but I'm saying to this point that is what we have. We have some sort of objective evidence, is what the cases always talk about, objective evidence that the person, the defendant is in, or the person, the suspect, the individual is in jeopardy. Here, there's no evidence whatsoever to suggest that the person's in jeopardy. He's just engaged in normal everyday activity just by leaning into the trunk of his car. That is where we are at in terms of the appeals court decision. As I noted, it was made without any sort of argument at that stage. But what I'd ask this court to do is to, after finding the seizure, note that was happened without reasonable suspicion of criminal activity, to vacate the findings of the motion judge and reverse the decision to suppress the evidence in this case.
Thank you.
Thank you, Mr. Crouch. Mr. Surlett.
Madam Chief Justice, and may it please the Court, my name is David Sollett, Assistant District Attorney for Middlesex. When Officer Mann responded alone to this street, he responded to a report of a man armed with a bat and swinging it, and he didn't know for certain whether the man with the bat was acting in self-defense and whether there might be other assailants about. He didn't know whether he had driven off some intended victim. He didn't know whether he had been swinging his bat at some invisible phantasm and was somehow demented or deranged. What he did know was that at least one party in the area had...
You used the term armed with a bat. He was just swinging a baseball bat.
Swinging a bat, holding a bat, Your Honor.
Yeah, he was swinging a baseball bat.
That's
He's
correct.
not armed with a bat. He's swinging a baseball bat. I don't fault a police officer for going to see. Somebody calls in a report, the police officer goes. There's nobody on the street. There's nobody, there's no mayhem, there's no crowd, there's no nothing.
I think the reason why I say armed, Your Honor, is from the officer's perspective, when he responds and the bat is immediately beside, when he responds, he actually sees the bat first in the palm of Mr. Knowles
Yeah,
and then
he's
leaned
holding
against.
a baseball bat and he puts it down. I mean, the appeals court says, even if this wasn't, I forget the phrase, even if it wasn't outright criminal activity, I mean, I think the notion that swinging a baseball bat is criminal activity. Swinging a baseball bat in a crowded area or, but you're walking home from a baseball game and you're swinging a baseball bat.
Well, I think it depends on the context of where you do the swinging and how you do it. If you do it with fielders and pitchers on a baseball diamond
No,
with
you're
a glove...
walking down an empty street. You're walking down an empty street.
I think that the street here
I mean,
was...
it's fine for the police officer to go and look at it, right?
I guess what I'd suggest, Your Honor, is that at this time the street was not empty, that there were no other figures when the officer arrived, but clearly someone was there and disturbed enough to call the police.
He might have been driving past in a car. We don't know. He might have been in a building across the street.
And
You
I-
can't say that there was clearly somebody there, implying that it was, somebody on the street. We just don't know that.
I think if he was in a building across the street, Your Honor, and he called the police because he was disturbed, this anonymous person, that under
We
the...
have lots of calls and lots of cases, and thank heavens that people call the police. But the fact that somebody calls the police, there is somebody, parked in a car in a Milton driveway, right, who happens to be African American. They call the police. There are lots of reasons why people call the police.
I'm not trying to suggest, Your Honor, that every call to the police immediately creates reasonable suspicion, but in
It
this
doesn't
case...
create arguably criminal behavior, and it doesn't create reasonable suspicion.
In Commonwealth versus Piscopo, Your Honor, the court had held that where there are calls from neighbors for the police assistance, that could be used to draw the inference that the conduct was in fact disturbing
But now we
area
know
residents.
what the conduct was. He was swinging a baseball bat on what appears to be, from all of the evidence, an empty street.
Respectfully, Your Honor, I think that while if the trial court erred in using the word busy, it was within the trial court's ability to take notice. This was a
To
judge
take notice of what?
to take notice of the fact that this was densely populated. Perhaps he should have said residential area or densely populated rather than busy. But in context, at 6:40 p.m.
I've just played my baseball game. I won. I'm walking home. I'm swinging the baseball bat. It's a residential area. There's nobody on the street.
I guess I would say, Your Honor, that somebody had to be in the immediate proximity at that immediate time, or they
in the
couldn't have
house
made those
across the
observations.
way or in a passing motor car.
And within seconds, because the officer responded to the call, his description was within seconds. At
Fine.
that point, what I suggest is that he had the responsibility to respond to that report, to see if there was a crime
No
or there was a
question.
danger.
There's no question. The
No
officer could
question.
have pulled up alongside and said, geez, we got a report that you were swinging the bat.
Anything
What's
wrong?
going on? Anything wrong here?
And though the trial
Perfectly
court,
appropriate.
though the trial court didn't actually cite the case in its findings, Your Honor, I think that the principles that the trial court based its decision on, the decision to deny the motion to suppress, was the case of Commonwealth versus Fraser, where this court found that the responding officer, who did not have a reasonable suspicion, had enough to respond, but not reasonable suspicion, had a duty, nevertheless, to investigate the report of an armed man at the location
An
where the
armed
defendant
man
was
is
found.
very different.
Well, I think a handgun, Your Honor, is also not always illegal.
A handgun is not always illegal. A handgun is almost invariably dangerous.
And I think a baseball bat, divorced from the context of baseball, being swung in a way that alarms at least one person.
So are you saying that when the police officer pulled up, saw that this was a man, there was a baseball bat next to him, that that was reasonable suspicion to seize him?
I think that is correct, Your Honor. I think that the Commonwealth, it doesn't have to have been reasonable suspicion for his conduct to be justified. There's an alternate basis.
All right, my question, so was there reasonable suspicion or not?
I think in this case, when he first sees him...
You get a report, somebody was swinging a baseball bat. That's reasonable suspicion to seize him.
In this case, before he made any
No, not in this case, because that's all we have.
I think it depend on the context of how that person
There's no context.
arrived.
That's all we have.
Well,
we have no bystanders. We have nobody in the way. We don't even have him swinging the bat at the time. We have an anonymous, fine, absolutely can respond to the report.
This officer did have something more than that report before he made any verbal contact whatsoever with the defendant. That is, he saw the defendant saw him, the defendant reached in his pocket, and he threw some unknown item. He couldn't see what that item was.
And that's reasonable suspicion of what?
I think together with that builds the suspicion that there's some suspicious activity and that this person
I'm sort of with the Chief Justice on this. There's no reasonable suspicion of anything with respect to that baseball bat. So if there's reasonable suspicion, it's got to come from someplace else. So throwing something in a trunk when you see a police officer is reasonable suspicion that they've committed a crime?
No, Your Honor. I wouldn't say that throwing anything in the trunk. But I think in context, when you're responding to a report of a baseball bat, something that obviously alarmed at least one citizen, and the response of the individual when the officer arrives is to throw something. Perhaps not a quote, furtive gesture because it was made obviously in the officer's sight, but something that would alarm an officer who was alone face-to-face with an individual who had a baseball bat within arm's reach.
Could have been a handgun.
Could have been a handgun, could have been a knife, could have been brass knuckles. At that point, the officer just didn't know. There also was the car trunk, which from his original vantage point, he didn't know what was in it. That could have held even a larger and more dangerous object.
Yeah, but that's true anywhere on the street. You drive from this courthouse to wherever your office is and just count the number of times that somebody is throwing something into a trunk.
The difference here, Your Honor, is that a citizen called the police and asked them to respond.
Because they saw somebody engaged in absolutely non-criminal behavior and they were concerned for whatever reason.
I guess I wouldn't agree, Your Honor, that the swinging of a baseball bat in a context divorced from baseball is always non-criminal behavior. It might have been innocent behavior. And the officer was there to verify whether it was or was not.
If the officer had a right to at least make the inquiry, and based on a report of somebody having seen presumably this fellow walking down the street swinging a bat, apart from whether it was innocent or criminal, was it unreasonable, and apart from the question of reasonable suspicion to believe that a crime had occurred, was it unreasonable under the Fourth Amendment for this police officer to say to that man, I want you to step away from the car?
No, it was not, Your Honor. What would be unreasonable, it would be if a law enforcement officer responded to that description and chose to do nothing. If he let a person who had just been the subject of a citizen complaint, armed with an implement that, while it has an innocent purpose, is also clearly lethal, if he simply let that person...
There's a big difference in making an inquiry, pulling the cruiser up across the street and saying, can I ask you a few questions? Not a seizure, we know that, and that's one way to deal with it. The stop right there, put your hands where I can see them, come toward me, that's a seizure.
I guess what he said here...
Unnecessary to the inquiry.
What he actually said here, Your Honor, was, I actually told him to stop at this time and then to just come towards me, and as he did, that's when other officers pulled up. In the Commonwealth
He didn't say, keep your hands where I can see them?
He said, that's when I ordered him to keep his hands out of his pockets and start walking toward me. But they were already out of his pockets. So there's certainly less of an intrusion to tell someone whose hands are not in their pockets not to put them there than to order, as happened in Fraser, someone whose hands are pocketed to take them out.
Did the officer testify to any apprehension at all about this guy?
He did. He indicated that his conduct was, the reason why he made this order to approach was for officer safety, and he also indicated that his approach to the trunk was out of a concern for officer safety. It was made after the other officers had arrived, but he wanted to verify whether the item in that trunk was something they had to be worried about as they had their inquiry with Mr. Knowles.
We say that a seizure occurs when a reasonable person wouldn't be of the belief that they could just walk away. Do you think that Mr. Knowles, when he was told to stop right there, keep your hands out of your pockets, come over here, that a reasonable person in that situation will believe that he could just walk away and not?
I think our case law suggests that that is not necessarily a seizure, that in the Barrows case, there had to be two commands before a seizure happened. First, when a uniformed officer said, "Hey, you, I want to talk with you," clearly the officer did want to talk with him, but the person was free to ignore it if they wanted to. Only when he chose to ignore it and the officer again said, "Hey, you, stop."
Hey, you, stop. In other words, you're not permitted to move. All right? That's a seizure. Didn't we say that was a seizure?
I don't think it's always a seizure, Your Honor. Sometimes
In
it
that
used to
case,
be
didn't we say that was a seizure?
the second time after he had
Hey,
first.
you, I'd like to talk to you is different than stop right there.
But I think
Turn
it's-
toward me, put your hands where I can see him, come over here.
in the Barrows case, though, Your Honor, it was the importance that this court underlined was that it was the second request. That the officer in that case demonstrated that a declining to comply would be met with another insistence. In this case, there was simply compliance, and he didn't have to be told again. He also wasn't moving, unlike either the subject in Barrows or the subject in Stout. Both of them were trying to get from point A to point B, and the officer stopped them from going where they wanted to go.
Yeah.
Mr. Knowles was stationary.
My questions haven't really been directed at whether or not there's reasonable suspicion to believe that a crime occurred, because I'm not so sure there was that level of suspicion. It's just whether in the circumstances here, the seizure was reasonable under the Fourth Amendment for purposes of the officer's sense of safety.
I think that it was, Your Honor, and the reason why is that we expect this officer, and I think our case law says that we expect an officer to approach, to find out what's going on here, and that he's not required to abandon his own personal safety when he does that. I point out that what he does, what he asks this person to do, or what he tells this person to do, is minimally intrusive. The entire interaction takes between 20 and 30 seconds in the officer's estimation. He doesn't put his hands on the person. He doesn't draw a weapon. He simply moves him away from the two things that he's afraid of, the bat and...
May I ask a question about the appeals court opinion? In the opinion, they made reference to further indication that the defendant was behaving oddly. Remember that?
I do.
What was the odd behavior that they referred to?
I think the first indication, Your Honor, is that report from the citizen. That while it was described that it was 6:40 p.m. and they didn't get more into the details, 6:40 p.m. is, I believe, 4 minutes from sunset at that time of year on that date. So it's a low light. It's not on a baseball field. There's no pitcher.
It's
There's
when
no
the
teammate.
baseball game is finished and you're walking home.
I'm not trying to say, Your Honor, that everybody with a baseball bat, but in context, clearly somebody was alarmed, and that was a concern.
That's the
People
odd
see-
behavior?
I think it is, Your Honor. People see people coming to and from a ball field all the time. It rarely generates a police call. When it does, there's a reasonable inference that there's something more than that there's something that's violent and scary. That's what would prompt a call to the police.
We don't have there's no evidence in the record about the proximity of a baseball field to this or, anything like that.
That was not in the record, Your Honor. No, I think the suggestion is that there was no sporting equipment, teammates, and I suspect, and I think the court could have found that that was part of what was suspicious about this context, that this was a situation where a baseball bat, clearly a legal implement, like a sword, can become dangerous. A sword is also not a per se prohibited weapon, but if an individual is swinging a sword on an urban street and someone calls the police, I think the police would be obligated in their duties to respond and figure out.
No question.
So this was sort of an American version of the samurai walking down the street.
All joking aside, Your Honor, I think that there's substantially more murders with baseball bats and serious injuries with baseball bats than there are with samurai swords. And for that reason, I think the officer had a reasonable fear for his own safety and took minimally intrusive steps, if intrusive at all. Thank you.
Thank you, Mr. Sellers. We'll take a short break.